I want to talk with you this session just beginning about political limitations on freedom of what we would call freedom of expression, speech and press, somewhat interchangeably. Mill makes the famous argument, which leads to a notion of the marketplace of ideas. Mill makes the famous argument, in his context, the issue was religion, and why should the religious allow the non-religious to preach their false ideas? He says one must begin with a certain intellectual modesty, and you have to at least consider the possibility that if you silence the opponent, he may have truth. Some notion of modesty or perhaps skepticism, I'll come back. Secondly, Mill continues, you have to consider the possibility, though you are substantially right and he is substantially wrong, if you silence him, you lose out on the ability to get that piece or aspect of the truth which your opponent has, dumb though he may be in the remainder of his arguments. And finally, Mill says, and I think it's an interesting issue, even if you are completely right and even if he is completely wrong, it is a good thing not to silence him. Why not? Because you who are not challenged will hold your values as a mere superstition or prejudice or unreflected point of view, whereas you've all heard this argument, and you know the way it plays out. The competition in the marketplace will produce a better mousetrap, and the competition in the marketplace of ideas will produce a better understood argument or words to that effect. And what I stress in the reference to Mill is that the value that he is perpetuating, perpetuating, why should we have freedom of expression altogether, is a social good. The society is better off when there is competition in ideas as in other things. Let me mention another theory that you may or may not know the author of. Professor Alexander Meiklejohn, a distinguished writer in this area who was once upon a time a dean at the college at Brown University, went on to do other things. Meiklejohn wanted very much to make an absolute argument for free speech. And he realized that there were certain problems that were inherent in his desire to do that. His response was to create or attempt to create a distinction between political speech and non-political speech as follows. Why do we want free speech at all, speech press at all on Meiklejohn's view? Has to do with the notions of self-government. If we are to be able to vote, if it is a given that we may choose our governors and our social policy under which we are governed, it is necessary that there then be untrammeled freedom of debate. If you have the capacity and you believe it's important to be able to throw the bums out, somebody has to be able to tell you who the bums are. And thus, says Meiklejohn, free speech is derivative from self-governance. Why doesn't that complete the argument for Professor Meiklejohn? Because there are other kinds of speech, and there are other kinds of limitations on speech which Meiklejohn, I think perhaps uncomfortably, but came around to realize had to be recognizable. For example, fraud in the marketplace. I tell you that this is a Rolex watch, and I will sell it to you, my dear friend, along with the half price of a set of tapes, for a mere Scotch tapes, you know. I will sell you my official Rolex watch for $250 because we're such good friends. I mean, it's a Mickey Mouse watch from Woolworth's, and it's worth $3. That's a speech act. That's a speech act. Fraud. And Meiklejohn realized that there are a whole host of libel, what you want to do with libel. By the end, Justice Black, who tended to be an absolutist, came around to the position that there could be no law of libel. That was a price that society had to pay in order to have freedom of speech. So you've got Meiklejohn's distinction, you've got Mill on liberty, where the value ultimately to be served is truth in knowledge, about, in Mill's limited concern, religious issues, but we would today say all manner of other kinds of issues. And Meiklejohn makes the argument of speech to be most protected when that speech is relevant to self-governance. Upon reflection, I think his distinction doesn't work, or at least it doesn't work the way lawyers like things to work, with a bright line of distinguishing between that which is protected absolutely and that which is not protected absolutely. And the reason that it doesn't work, I think, will be pretty straightforward. It's difficult to know what issues become part of governance, especially in our day and age with tremendous involvement by government in all manner of events and affairs. Interestingly, and beyond our purposes, Meiklejohn's distinction possibly has been accepted by the Supreme Court in the law of libel itself, where to get a conviction with a standard for a libel conviction against what is called a public figure is different than the standard of that would allow a conviction of libel or slander against a private citizen. The public figure, like your senator, has placed himself in the public eye, and therefore if the press gets a report that X with respect to your senator, it's good for governance to get that out more without fear of libel and so on, as distinct from when the press discovers John Doe citizen having whatever it is that he has for breakfast and libels John Doe citizen. We have less of a concern. It's easier for a non-public quote-unquote citizen to win in a libel action than it is for a quote-unquote public figure. Examples from elected office will be very straightforward. What about people that we have a sort of titillating interest in? They publish that Mrs. Onassis went skydiving in Florida, and it's not true. Is Mrs. Onassis by definition a public figure because of our prurient interest, or because of, in order to know how to vote for the next president, you have to know as much as you possibly can find out about the guy that became president in 1960? It doesn't sound very convincing even as I say it. Mill, we want to perpetuate truth. Meiklejohn, derivative from self-government, so political speech is absolutely protected, and other forms of speech are not absolutely protected. Commercial speech. Commercial speech. I want to sell you my Rolex. That seems to me not to be terribly difficult to restrict. I want to tell you that my hotel chain is the best hotel chain in the world and better than anybody else's hotel chain. And the other, I don't know how much commercial television is deserving of protection. Play with it as a notion. How far does commercial speech get you on a non-absolutist basis? The organized groups on behalf of the elderly have won in litigation that changed, that limited attempts by states to prevent pharmacies from advertising drug prices. It was held to be a federal constitution, at least in some circuit courts, it was held to be a constitutional right to communicate the price of pharmaceuticals, especially to the elderly population who spends a lot of money perhaps on medications. And commercial speech, not commercial speech, is the price of aspirin political, or of heart drugs, or Coumadin, or whatever people are taking? Is that part of self-government? I mean, it's not so hard to make an argument about relevant to Medicaid and how much Medicaid has to pay and all manner of health policy kinds of issues. And of all of the speech acts which occur in the world, how do you know which of the ones you want to protect and how do you know which of the ones you don't want to protect? Will play out a lot on your theory of what the function of speech and or press might be. I want to come back to both Mill and Meiklejohn, but let me make the following point first. What I presented in their names defends and justifies freedom of speech or of press in terms of the social benefit. Society will be better off with better mousetraps, so to speak, because of this competition of ideas and stuff like that. Society will govern itself better if an active and vigilant press finds out for us every item known about every public official or person who wants it, etc. There's another way to think about expression. There's a way to think about expression. We'll talk more about it, I think, in the next session. There's a way to think about expression as being relevant not particularly to the audience, but to the speaker. When I paint my great painting, when I write my great poetry, this is all hypothetical, you understand. When I write my great poetry, when I sing my great song, I mean, I'm delighted that it helps you govern, but maybe it has a lot to do with me and my expression and my creativity and my wish to make certain things reflect my inner drives and my integrity. whether to think about speech press in terms of benefits to society and or how to consider speech press and the like in the context of me as a creator, of any of us, of course, of me as a creative speaker, painter, writer, and thinker. What is speech? We know what speech is. What is speech? Does it require verbs? Does it require voices, I should have said? Does it require, must speech be heard? I'm not sure what the rules are on televising this tape, and I'm not insulting anyone. Can you imagine gestures I could make with my hands, which could be called obscene or offensive? Or, I mean, if I didn't have a tremor and could use all my fingers carefully, could I speak to you with my fingers and not say anything in particular? I digress very slightly. An attorney I know had the following case presented to him. Wise-ass high school seniors in a certain public high school posed for their class picture. By prior arrangement, they held their hands in interesting ways, like on their genitals, or like with one finger protruding, or like several others, which I don't know what they mean, but they were clearly very expressive. The school board published its yearbook with that picture in it before anybody noticed. This kid who had been admitted to an Ivy League school was told that they would notify the... so what do you do in America? Of course, you can't talk to grandma anymore. Called a lawyer who wrote a free speech justification. And the case was settled quietly on the side. Speech acts. Does there have to be an intent to communicate? A bona fide intent to communicate. What does that mean? We'll talk more about this again next time. A street person is living on the street and yelling at passers-by. I mean, he's yelling. He maybe even is diagnosed as marginally psychotic, but he's yelling at 11 o'clock at night using a lot of swear words and upsetting people who live there. But of course, those are the same people who get upset when Martin Luther King Jr. brings his let us live wherever we want parade into their community. So a lot of things upset people. Should we understand the street person who is screaming obscenities as dealing at all in any of the categories that we are speaking about this afternoon in terms of speech or communication? Does there have to be an intent to communicate? And how much of a difference does that make, the intent to communicate or the absence of an intent so to communicate? The position of John Stuart Mill on liberty comes very close to a very famous judicial opinion by Mr. Justice Holmes in a case called Abrams. You may vaguely remember from your reading that following World War I in this country, there were a variety of attacks on what we would call civil liberties. There was something called Palmer Red Raids. There were, interestingly, persons elected to the New York State Legislature on a Socialist Party ticket who were not permitted to be seated in the legislature, which was upheld ultimately by courts, were not permitted to be seated in the legislature because as socialists they could not be believed when they took the oath to uphold the Constitution. Not so long ago. In that context, lots of people who published lots of little pamphlets and stuff like that were arrested for sedition, typically, and these cases worked their ways up through the courts. Holmes, in Abrams, dissenting, makes essentially John Stuart Mill's argument that it is essential to our system of government that no public official may define standards of orthodoxy, with respect certainly to political belief, but that ideas, no matter how hateful and how detestable those ideas might be, must, in a vibrant society, be permitted to go forward. Why? For John Stuart Mill's reasons. What I want you to think about is the extent to which Mill, Holmes are being skeptical. We may not have the truth in our hand, but it exists somewhere, and we have to be willing to work hard to find it. And if we work hard to find it in a good way, then we will all be better off, though it is really very unpleasant and obnoxious to have this demonstrator outside our political party meeting, or indeed, as I have heard, very unpleasant to have on the Yom Kippur, the Jewish Day of Atonement, to have socialists and radicals publicly eating ham sandwiches outside the synagogue as a way of sort of poignantly attacking what they thought was the silly religion of the observant. Is eating a ham sandwich a speech act? I don't know. Worthy of thinking? Nah, not worthy of thinking about either. Knowing what it is that you want to protect is indeed worthy of a lot of attention. The issue to think about at this point in the discussion is whether you yourself or others whom you have read or Holmes, whom I have read, and Mill, are skeptical or think it necessary to act as if skeptical about the existence of truth, that I have it, as opposed to the notion of skepticism that there is such a thing as truth at all. Is it that we can't know and are reduced to a utilitarian analysis of who will gain and who will lose and how much will you gain and how much will I lose, because that's the best we have in our society? Or is it that other values do exist and ways of relatively comparing them exist, but in any particular dispute or any particular setting, it may well be that we ought to permit the things to go forward, like the Nazis marching in Skokie, for the reasons given. Not that I want to say, if I vote to let the Nazis march, not that I want to say that I don't know they're wrong. They're wrong. But one has to allow the challenge to our own views and so on and so on and so on and so on. All right. Two ways of looking at the level of skepticism which one might have in such a case. What is speech? Real examples in the real world. Is burning your draft card speech? Some of you are old enough to remember the Vietnam War and protests. Is burning one's draft card a speech act at all? Is burning a flag? You have noticed that that's been dealt with in the Supreme Court relatively recently. Is burning a flag a speech act at all? I'll give you one which is true and which plays a little better into the next class, but we'll run it on this one anyway. During Vietnam there and the protests there too, there was an off-Broadway production, the name of which I don't know, in New York, which involved at a certain point lighting butterflies on fire and releasing them to fly over the audience as a way of graphically calling their attention to the issue of napalm as it was being used. I never saw that. I don't know how my gut would react. You may well want to wonder how you might react. It was the kind of political protest. It, I suppose, was exceedingly graphic. I suppose the issues of the napalm in Vietnam are indisputably political issues which ought to be addressed in the and why are the sensibilities of butterfly lovers any more worthy of protection than the sensibilities of Holocaust survivors in Skokie, Illinois? Is it a speech act? Language comes up, symbolic speech, or excuse me, symbolic action, burning a draft card, a flag, whatever, picture, photograph of the President of the United States. Is it a speech act, and or what would be countervailing considerations which would justify not protecting such issues? Holmes' phrase, as I mentioned earlier in another case, clear and present danger. Falsely shouting fire is a clear and present danger. The New York Times had the story on the Bay of Pigs invasion before it occurred. Do you remember the Bay of Pigs invasion? Early in John Kennedy's presidency, having to do with the effort to oust Castro. We were involved to whatever extent. There were an army of Cubans, expatriates, I think in Guatemala, I may be wrong. And one of the things that Kennedy discovered when he became president was that we had been supporting the training of an army to invade Cuba. And the plans were they were to go on a certain date. The Times knew a day in advance. The Times did not publish that story. Should they have? Should they not have? Does your answer depend on the fact that you know what happened afterwards? I mean, if the Cuban people had risen up and overthrown Castro, almost as absurd as believing that everything else that's falling apart in the Soviet Union wouldn't be. If, and so on. Should the New York Times have been permitted, required, prohibited? It was quote-unquote peacetime. Should the Times have been permitted to report that or not? is the only kind of danger that clear and present danger refers to. Remember, as overruling freedom of speech, is the only danger that clear and present danger refers to life and death. What about money? What about the New York Times? I'm making this one up, but it's not far off the truth. What happens if any network, CNN or whatever, gets information that the day after tomorrow, the governor of your state is going to close all the banks? That's tremendously significant to all kinds of us and all kinds of business people and all kinds of commercial people. And the governor has been considering a variety of responses to a particular financial difficulty, which is very realistic in the modern day of economic problems. And the Times gets a good story as to which day, at what time, the banks are going to be closed. First question, is that political or not political? I think the answer is straightforward, that it is. Second question, you want to say with Meiklejohn that there's an absolute right to publish that? To publish it before the banks are closed? So that, well, you can play out the rest of the story as you like. Is freedom of expression the phenomenon, both with respect to speech and press, such that it is meant to be understood in terms of instantaneous? I now wish to speak, you now, a police officer, wish to stop me, or is it to be understood, at least in some cases, it's not so bad if we shut you up for 2 days and let the Times run its story about the banks the day after the banks were closed? Well, of course, some people will wonder why they weren't told earlier, and if the Times, I'm picking on the Times, if any newspaper knew in advance how it was to be, people could A, move their money, B, move their money, C, move their money, D, pressure the governor not to change the policy of the state and to let it go another month, and so on and so on. Is it crystal clear to you that if you had two choices, either to be told 2 days in advance about the Bay of Pigs invasion, or to be told 2 days in advance about a bank closing in your state, is it obvious to you that you would pick the war and peace issue over the financial issue? It's something for each of you to think about a bit. What is it that competes with speech? Considerations of what? Clear and present danger in the context of falsely shouting fire in a crowded theater is easy. It's an immediate carnage that we're seeking to avoid. I'll come back to this, but it fits nicely now. In my own hometown of Providence, Rhode Island, there was an incident in which a guy had some guns in a house, and he may have had children there, and no one knew if he had children there, and he was shooting out the window randomly, and the place is surrounded by the police SWAT teams and by the media who are televising this. And they're televising the SWAT teams coming around this house in which this guy has an arsenal, may or may not have a kid hostage, and may or may not have a television. So he may be watching on television. You see the point. I don't remember what the media did, whether they were asked by the police to cut it off. What should they have, and just not broadcast simultaneously until anybody found out if he was going to give himself up or shoot the child or whatever the story. Is it really much of an intrusion on freedom of speech if they said to him, wait a half an hour? Wait about 2 days. Wait about 90 days until after we get this guy indicted, because we don't want your film footage to foul up the indictment procedure. That already begins to sound a bit scuzzy. What are the factors that ought to constitute as danger in contrast to the efforts of the speaker to speak or the publisher to publish? I mentioned earlier the notion that I think properly our society seems to have rejected, which is the notion of the heckler's veto. Just because there's a mob that doesn't think a person should speak as an atheist or as a communist or as a Republican or as a socialist or as a Democrat and so on, does not justify, I think, attempts to silence, especially in an overtly political context of that sort. Are the electronic media the same? Are the electronic media different? There are a number of ways to begin to approach the issue. One, which I've mentioned already, is the notion of simultaneity. The ability of, as we sat in our living rooms watching Scud missiles fly, which I presume people were glued to their televisions, to be understood in the same frame of reference as a reporter files a report and then it gets back and then it gets published, and then how important is the distinction between the electronic media and the press media that has to do with simultaneity? More, how relevant, if at all, is the notion that radio and television have reached a much larger impact, audience than do the print media? Relevant or not relevant? Would you hold the New York Times and Wall Street Journal to different journalistic ethical standards or even legal standards than you would hold the local community weekly newspaper? The ability of the electronic media to impact in your home when you're not there and your kids are. I haven't said much about kids today. It is argued that, and think of it as you like, it is argued that the electronic media get the junior when you're out working hard or sleeping late on Saturday morning, and thereby with Bugs Bunny destroying his entire work ethic. The issue of parents and controlling and not controlling, relevant or not relevant. There is a very interesting opinion in the United States Supreme Court in a case called Red Lion versus the Federal Communications Commission, which roughly goes like this. A Christian preacher, whose first names I don't remember and whose family name is Hargis. Anybody? Billy Joe. Thank you. Billy Joe Hargis. Was a right-wing, I think that's, he would agree with that, was a right-wing missionizing preacher who had a radio or television show, and I don't know what all else he did. In one of his broadcasts, Mr. Hargis denounced a then-current book by a journalist named Fred Cook. It was a book with a leftist perspective. Having denounced this book by the leftist, Mr. Cook, on his radio broadcast, Hargis went about his business and Cook sued. Cook sued for equal time to reply. Why did he think that he was entitled to equal time or any right to reply whatsoever? Because the Federal Communications Commission had at that time issued a series of regulations promulgating access to the electronic media, promulgated the regulations regulating access to the electronic media, and they included a number of interacting regulations, all of which, by the end of my story, are held constitutional, some of which have already been repealed under the Reagan administration's movement in many areas to minimize government regulation, and some of which, as it happens, are currently controversial in the Congress this term. Basically three. A right called the doctrine of fairness, one called the right to reply, and the third, which you know something about, called the equal time doctrine. Fairness. The fairness doctrine put a positive obligation on those with television and radio licenses to adequately, I think that's verbatim, to adequately cover and fairly report news of public interest. What was the case that was had in mind by such a regulation? There were southern radio stations for the purposes of which black people did not exist. No news would be broadcast about issues involving blacks on that radio station or that television station. The fairness doctrine, the requirement fairly, or adequately, but fairly to cover issues of public importance, and if there were no spokesman to come forward to represent those public issues, the station was obliged by the regulations of the Federal Communications Commission to, at its own expense, obtain such commentary. I personally benefited from that. Not in Mississippi. While on the faculty at Brown University, I got contacted by a local rock radio station which wanted an appointment. We talked for a while, and could I do something of 1-minute public interest spots with the relevant to the then coming up presidential election? I thought it was wonderful that this commercial channel that broadcasts student-y rock music would come to me because of the quality of my ideas and so forth. I think what happened was I was cheap local talent. What I learned ultimately was that their license was up soon, and their lawyers had told them that they didn't have enough public interest stuff. The day after their license was reapproved, I lost my 5 times a week spot. People change their minds as to what's important. You don't have to be too much of a Marxist to notice some things. Fairness doctrine. It's extraordinary. It's extraordinary. Why is it extraordinary? Because of what are the phrases that I bothered you with in earlier sessions that apply exactly on this case? What is the difference between telling a radio station that it must have a licensed engineer on the premises at all times, that it's on the air, and telling a radio station that it has an obligation fairly to report on issues of public interest? What's the difference? The key phrase that I gave you is the phrase content neutral. If there is anything, the man said, that is central to American theory of First Amendment rights, it is that no government official can decide what is orthodox and what is not orthodox in terms of beliefs. So you got lots of kinds of regulations that if they put up a radio tower, it's got to have a red light on the top. Not Rudolph the Red-Nosed Reindeer, but a red light on the top, and I suppose there are regulations about how often it has to be checked and how bright does it have to be. And sure, anybody's radio station has to have that. A light on the tower, health safety, that's easy. That's easy. The notion of the regulations which have been upheld constitutionally in the Red Line case are that we can tell the radio station that if they want to continue their license, the content of their broadcasts are subject to scrutiny. And they have to make good out of their own pocket on producing such countervailing points of view. Held constitutional, the theory being there is limited access to the airwaves, and the airwaves are a public trust. Would you approve of a notion that in order to keep its license, incidentally, why does anyone care about federal communications regulations? Why does, I mean, you lose your license. Well, big money, right? In order to be in the business, big money. You need fairly to cover and adequately to report on the content of that which is important in the news. What would that sound? And then the other two, which were actually in Mr. Cook's case, the right to reply. If you're named as a bum, you can request the time to compete. And the one that you probably all know about is voters, the equal time requirement. How do you know about it? If a political candidate is given access to the airwaves, then his opponents must be given access on the same terms and on the same conditions, which meant when the initial debates for presidential elections came forward, all candidates asked to be included, not only Republicans and Democrats, but socialist workers and vegetarians and whatever they were on the ballot anywhere asked to come forward. Statutes of Congress were required to exempt presidential debates from this notion of if you let on one, you got to let on everybody. End of digression. What would be the equivalent case in the print media? The equivalent case in the print media would be something roughly like if a newspaper names you, then they are required to print your letter to the editor to say that you are not a bum or whatever it is that was at issue. States adopted such legislation held unconstitutional in the Miami Herald case. So there is the extraordinary, I think, anomaly that in the United States today, the electronic media are subject to governmental regulation to an extent which print media are not subjected to. The logic is an inarticulated, well, no, excuse me, and a very articulated but not so well considered notion that the airwaves are a public trust, and then the argument of scarcity. If I don't know the New York stations anymore, if CBS is channel 2, yeah, and I go to Radio Shack and buy a handy-dandy broadcast kit, and I figure I'll broadcast television on channel 2 or on the radio, the result is mud. Without government regulation, there is no free speech. Obvious. Wow. Without I mean, it sounds like George Orwell. Without regulation, there is no speech. So my oldest son has to go to the eye doctor. I grab him. We get in the car. He's giving me a tough time. I said, we're in a hurry. Hurry up. We stopped at the red. Why did you stop? But there's a red light. I thought we were in a hurry. I don't strangle him. At least I don't admit to it on television. And I say to him, profound insight, we're able to do, we can get there faster if we stop for every red light. Because if I have to come to every intersection and wonder about whether you're going to come through with a truck in the other direction because there are no lights, So says I, that's Thomas Hobbes, by the way. That's Thomas Hobbes, by the way. Hobbes, law is the command of the sovereign, and we're better off with that law. No, Beiser. Free speech, free press, absolute freedoms. Absolute freedoms mean that you get to the eye doctor faster if you know who else is going to stop at the traffic light at each corner. And when the lights are out, we drive very, very, very carefully. So it's obvious for the electronic media. Why isn't it just as obvious for the print media? Incidentally, in 1991, and I don't know, but as just as citizens, or some of you be in the business, your intuition that there's more access to the television media now or to the print media? Easier to have something broadcast on television in your hometown or in the press? Probably so. Entrance barriers, as the economists like to say, have significantly been removed now that we have UHF and VHF and satellites and all these 64 channels. And one of the ways to look is, when we were little bitty kids growing up, there were many cities in this country that had many, many newspapers. And how many cities are there today that have many, many newspapers? And I'm back now to, is that a free speech kinds of issue? Red Lion, the fairness doctrine, stands for the proposition that the government has a positive obligation, or the government imposes it as a positive obligation on broadcasters to meet a public need, fairly and adequately to present. Fairly and adequately to present. Marketplace of ideas. Switch images with me to the New England town meeting. My obnoxious child with the red light bit is roughly equivalent to, how can you have free speech if someone presides at the meeting? So you tell the kid that you can't have speech without somebody providing. If we all go to a meeting and there are 60 of us and no one presides, there will be chaos, and therefore there's more freedom. Orwell again, right? Regulation means more freedom. Mr. Chairman or Madam Chairman keeps us more free by recognizing us. One way to be more free at the New England town meeting is for the chairperson to say, nobody speaks twice until everyone has spoken once. No one speaks when anyone else is speaking. Raise your hands and I'll call on you. That sounds very fair. A different way to think about fairness in the context of the New England town meeting is, I as chairperson will recognize you so that all important views will be expressed. 3 people having spoken in support of the amendment, who wishes to speak against the amendment? Different from the notion of first come, first served, different from the notion of no one speaks twice till everybody speaks once. Explicitly not content neutral. We've heard 3 speakers in favor of whatever the town's business is. Now we want to hear 3 speakers against whatever. And if there's no one there, maybe the town meeting president ought to call Boston and get them to send down an expert on whatever it is that they're talking about. Who will constitute an expert? We'll talk a little bit more about that later, but you hear the marketplace of ideas, analogy to an open and free market. When Mill and his friends were writing, automobiles, which had not yet been invented, were not recalled at requirements of the government. And we have a free and open a free and open market. We got all manner of truth in advertising regulations, and Toyota does recall cars because the feds require them to, and all automobile manufacturers. The government polices the meeting. The government polices the market. Is the market in ideas as needful of government policing as other markets, if you hold that other markets, industrial commercial markets, require policing? And if so, who is to decide and what limits? And I am busy unraveling the argument for free speech, which became, now how far, I say this in class and I bite my tongue, Red Lion, all of these impacts of the electronic media, you've heard me talk about it. Say I to the students, does this suggest that the notion of a marketplace in ideas, or indeed of democratic competition, is technologically outmoded? And I think that's a good issue to think about and a good point on which to conclude for the moment. We will pick up in a little bit. Having talked about censoring the dangerous, we will talk next time about censoring the offensive.